Good evening, everyone. It is both an honor and privilege to welcome you all to today's enlightening and thought-provoking lecture titled The Impartial Judge and Cross-Border Environment Litigation by Honorable Justice Anselmo, who served as a professor at University of Hong Kong as well as an international judge at Singapore Commercial Court. In addition to our esteemed guest speaker, we are honored to have with us our President, Shri Praveen H. Parekh sir, and our Secretary General, Shri Narendra Singh. Before starting with a formal talk, I would request our President, Shri Praveen H. Parekh sir, to present Professor Lees with a bouquet of flowers as a symbol of our appreciation for his kind therapy. The Conference of the Indian Society of International Law. Thank you so much, sir. Now, I would like to invite our President, Shri Praveen H. Parekh sir, to deliver his formal welcome address.
On behalf of all of you, my dear friends, we welcome Justice Anselmo Reyes for his visit to the ISIL. We also thank him for speaking on the topic of the impartial, impartial judge and cross-border environmental litigation. This is something which is necessary for all the countries all over. What type of judiciary do you have? And what are the powers of the judiciary? There are sometimes when the people who are ruling keep all the powers with them and they don't give any powers to the judiciary. By and large, citizens of any country would like to have a good judiciary because they can go to the judiciary in case there is the violation is done by the authorities who are running in names they have various people. There are two types of authorities. One is the parliament or legislatures, whatever by different names in different countries. And others are those who are running the thing as an executive. Now, both these things have to go to the judiciary. Judiciary can say that what you have done. It may be an entire parliament has made a law. Our constitution allows the judiciary to say no, you have passed it, but it is unconstitutional. It is contrary to our constitution. It is contrary to the rights given by our constitution to the citizens of India. So you cannot make such a law which will take away their rights. Our rights to go to the judiciary, of course, the judiciary can be A versus B also, but I'm talking of against the government. There is central government, state government, there are corporations, etc. Against them, you can go to a writ petition and not a suit. You can directly go to either a high court or a Supreme Court. It is a fundamental right, you can directly go to Supreme Court, or you can go to the high courts, either for the fundamental rights or other rights which are violated by the governments or even as I said, even by Parliament makes any law which is unconstitutional, you can go to the court and say that this law should be struck down. Or the court will say you made this law, that it is remain in your Parliament house, but it will not be used, it will not be applied to the citizens of India. Therefore, it is a good uh, good things to live in India as far as I can get. Yes, that we are safe. And by and large, there is any difficulties anyone has, and there are judiciary does do a lot of work, which is sometimes the government say you is not your business. And they may be sometimes right also. It's not your business, but they are doing a good job. So people are happy that your business or no business, what you are doing is good. And that is what is helping in the judiciary to do what they can. Someone can say that why did you do, how can you do? But then they will find out some method of law to say why I can do. because your constitution says this, and therefore you have violated that. Therefore, I want to, as a judge, tell you that please don't violate the citizens. And the, our guest, the practice as a barrister, Temple Chambers during 1989 to May 2001, and then became senior counsel, Temple Chambers in May 2001 to August 2003. He became a judge for first instance High Court in September 2003 to 2012, then elevated to the judge in charge of the construction and arbitration list for a period of 2004-2008. He was a judge in charge of admiralty and commercial list during 2008 to 2012. Since 2012, he is a professor of legal practice, Faculty of Law, University of Hong Kong. He was representative of the 8th Conference in Private International Law, Asia Pacific Regional Office in Hong Kong from 2013 to 2017. On behalf of all of you, I welcome Justice Anselmo, Reyes, and we are very, very happy that you have come to ISI, and we welcome you. Thank you.
Thank you very much. How should a fair-minded judge respond to tortious or other claims seeking a remedy for environmental damage caused by a respondent? Increasingly, courts around the world face such tortious actions. The claims may be brought by the victims of the wrongdoing, but the claimants may also be NGOs, non-governmental organizations, engaged in strategic litigation to highlight the perceived environmental shortcoming of a multinational company or country. A significant part of environmental litigation is domestic in nature. By this I mean that many cases will involve purely domestic law with claimants and respondents domiciled in the same country, or a claimant suing his or her own government for the breach of a duty said to be owed under domestic law. Today, by contrast, I will focus on transnational claims. I will consider three paradigm cases. In paradigm case 1, an individual, Artaxerxes, domiciled in Xanadu state, claims to be the victim of adverse environmental effects allegedly brought about by the activities of Bucephalus Company, also domiciled in Xanadu. Artaxerxes, however, commences litigation in Yamazaki state against Bucephalus's parent company, Cassandra, which is said to be responsible in some way for the environmental wrong done to Artaxerxes by Bucephalus in Xanadu. Cassandra is domiciled in Yamazaki. In paradigm case 2, an NGO sues Cassandra in Yamazaki, alleging that Cassandra has breached domestic law of Yamazaki by authorizing or permitting its subsidiary or associated company, Bucephalus, to inflict environmental wrong on persons such as Artaxerxes in Xanadu. In paradigm case 3, Artaxerxes from Xanadu claims that Cassandra in Yamazaki is responsible for climate change effects, which have adversely affected Artaxerxes' life and livelihood in Xanadu. The three paradigm cases being cross-border situations, our hypothetical fair-minded judge, Yamazaki State, will probably approach the cases by first applying traditional conflict of law modes of analysis. In other words, at the outset, the judge will consider whether he or she has jurisdiction to hear a case, and if jurisdiction is established, what law, foreign or domestic, is to apply. In case 1, provided an arguable case can be shown that Cassandra, was responsible for Bucephalus's alleged wrongdoing, the court of Yamazaki State will likely accept jurisdiction. This is because a claimant is usually expected to seek out the respondent and bring an action in the place where the respondent is domiciled or habitually resident. In case 2, there is a complication. The NGO bringing the case must not only have an arguable case that Cassandra is somehow complicit in Bucephalus's wrongdoing, the NGO must also establish that it has standing under the law of Yamazaki State to bring a case against Cassandra. This is because the NGO is not itself the victim of the alleged wrongdoing, and most states have laws to filter out claims from busybodies with no immediate interest in the outcome of litigation. This is reasonable, as states do not wish to have their courts clogged by litigation initiated by professional busybodies who sue others merely for the sake of suing. In case 3, provided again that an arguable case is made out, the court of Yamazaki is likely to accept jurisdiction due to Cassandra being domiciled in Yamazaki. In all 3 paradigm cases, I have stressed the proviso that an arguable case must be shown. I suggest that this is precisely where the difficulty lies, insofar as traditional private international law analysis is concerned. This becomes readily apparent when we move to the question of applicable law. An arguable case must be shown under the applicable law. In the first 2 paradigm cases, although the environmental damage occurs in Xanadu State, the claimants will almost certainly wish to argue that the law of Yamazaki State, that is the law of the forum, is to apply. It will be the respondents who will want to rely on conflict of law principles in order to have the actions against them dismissed as patently unarguable under the applicable foreign law. Why is that? In cases 1 and 2, it will commonly be perfectly legal for Bucephalus to have conducted itself in the way that it has in Xanadu. It will thus be fatal to the claimant's action in cases 1 and 2 if the Yamazaki court applies the law of the place where the environmental damage was sustained, that is, the lex loci damni, a typical connecting factor in tort actions. It will be equally disastrous for the NGO and Artaxerxes if the court of Yamazaki applies, as several common law jurisdictions and Japan, a civil law jurisdiction, do, a double actionability test where a foreign tort is concerned. Whatever the law may be in Yamazaki, Bucephalus's conduct will not be actionable ex hypothesi as a civil wrong in Xanadu. The Boys and Chaplain exception to double actionability in common law states will not help either, since the alleged environmental damage is likely to be characterized as having a closer connection with Xanadu, where the environmental damage is said to have been sustained through Bucephalus's actions, so closer to Xanadu rather than Yamazaki. The NGO and Artaxerxes will prefer that the court of Yamazaki applies the typically more stringent duties vis-a-vis the environment imposed by the domestic law of Yamazaki State on businesses operating in Yamazaki. The NGO and Artaxerxes, the claimants, may even be seeking to take advantage of the often more generous discovery or disclosure rules in Yamazaki to obtain documentary evidence linking Cassandra to Bucephalus. That would assist the NGO and Artaxerxes in making out a case of Cassandra's responsibility for and consequent complicity in Bucephalus's environmental shortcomings. In brief, the NGO and Artaxerxes will need to establish an arguable case that Bucephalus's environmental wrongs can be attributed to the breach by Cassandra of its duties of due diligence under Yamazaki's domestic law. In case 2, there is the additional complication that the NGO must establish that it has locus under the domestic law of Yamazaki to bring its action. The position will be analogous in paradigm case 3. Here again, Artaxerxes will wish to rely on the domestic law of Yamazaki. Xanadu may or may not have a law requiring persons whose activities contribute to climate change to compensate the victims of the same. If Xanadu does not have such a law, all the greater will it be Artaxerxes' wish to rely on Yamazaki's domestic law. If Xanadu does have such a law, it may not be of much avail to Artaxerxes if Cassandra has no apparent connection with Xanadu, placed with damage. As a matter of practicality, Artaxerxes would still have to seek out Cassandra and mount an action in Yamazaki as the place of Cassandra's domicile. What distinguishes paradigm case 3 from paradigm cases 1 and 2 is the question of proof. How precisely does Artaxerxes establish that by reason, say, of being responsible for high levels of greenhouse gas emissions, Cassandra in Yamazaki should be held liable for the alleged adverse climate change effects suffered by Artaxerxes in Xanadu? Even if Yamazaki's domestic law allows recourse against Cassandra in respect of adverse climate change effects, how exactly would responsibility be established? In the absence of evidence to a requisite standard, Artaxerxes' action against Cassandra is likely to be dismissed. Somehow or the other, Artaxerxes must bridge what I shall term the evidentiary gap between Cassandra's activity in Yamazaki and the adverse climate change effects alleged to have been suffered by Artaxerxes in Xanadu. Now, in the remainder of today's lecture, I will explore, time permitting, how the courts of 3 jurisdictions, 2 civil, 1 common law, have grappled with the paradigm cases 1 and 2. I shall focus on one of the more successful techniques that claimants have used to establish a prima facie case of Cassandra's responsibility for environmental wrongs committed by Bucephalus in Xanadu. The technique has been to argue that, in breach of its duties of care and due diligence under the domestic laws of Yamazaki, Cassandra has failed to exercise proper supervision over the potentially harmful environmental activities of its subsidiary or associated company, Bucephalus. I will then set out some thoughts about using a country's domestic legislation on environmental standards to advance ESG, environmental social governance concerns beyond that country's borders. I will conclude with a few words on how international norms may go some way towards bringing the evidentiary gap in case 3 to a close. Let's deal with paradigm cases 1 and 2. Let's start with the first of the 3 decisions I hope to look at. Amis de la Terre and Sherpa against Perenco. The French case of Amis de la Terre, French for Friends of the Earth, and Sherpa, another NGO, against Perenco, is effectively paradigm case 2. Amis de la Terre, Friends of the Earth, and Sherpa are French NGOs with the objective, among others, of preserving the environment from ecological damage. Perenco is a French oil company. Friends of the Earth and Sherpa applied to the French court under Article 145 of the French Code of Civil Procedure for pre-action discovery against Perenco. They sought an order that Perenco surrender documents in its possession that may be probative of its de facto control or dominant influence over the activities of alleged subsidiaries in the Democratic Republic of the Congo, DRC. The discovery was sought for the purposes of a future action which the claimants intended to bring against Perenco for environmental damage in the DRC caused by the alleged subsidiaries' activities, alleged subsidiaries of Perenco. The subsidiaries' operations in the DRC had been much criticized by the Congolese Senate, local associations, and international NGOs for serious environmental violations. The Paris Court of Appeal refused the claimants' application. The claimants did not contend that they had suffered harm due to Perenco's or the subsidiaries' activities. Others may have suffered, but not the NGOs. The court further rejected the contention that the applicable law was French law. The court did so on the ground that France was neither the place where the alleged environmental damage occurred, to be the DRC, nor the place where the event giving rise to such damage had occurred. Even if Perenco's DRC operations caused environmental damage, and Perenco did not admit that it had a subsidiary in the DRC, even if the Perenco could be said to have DRC operations that caused environmental damage, the act was committed in the DRC, and the applicable law would be DRC law. Under DRC law, Perenco's activities were not illegal. The intended future claim was accordingly bound to fail, and the court dismissed the claimant's case in consequence. But the Cour de Cassation, French equivalent of the highest court, overturned the decision. It held instead that the applicable law for determining whether the claimants were entitled to pre-action discovery under the Code of Civil Procedure, Article 145, was French law. The Court of Appeal had erred in refusing to apply French law. The Cour de Cassation therefore remitted the matter back to a differently constituted Court of Appeal for determination in accordance with French law. Friends of the Earth, Amis de la Terre, and Sherpa had submitted that their application being in respect of a future action, the French judge should merely, quote-unquote, verify whether the alleged facts could, if established, support the claimant's potential action. The NGO submitted that it was not appropriate for the judge at a preliminary stage to evaluate the legal basis and merits of the intended action. For the purposes of cassation, appeal, it was unnecessary to decide whether the NGOs had standing to sue. The Cour de Cassation consequently did not do so, leaving open the question of the claimant's locus standi to sue Perenco for environmental damage in the DRC for later decision. Okpabi and Royal Dutch Shell. Okpabi concerned environmental pollution, including water and soil contamination in the Niger Delta in Nigeria. The litigation was analogous to Paradigm Case 1. The claims arose out of oil spills from pipelines and associated infrastructures amongst communities in the Niger Delta. The respondents were Royal Dutch Shell plc, RDS, a UK domiciled company and parent of the Shell Group, and 2, Shell Petroleum Development Company of Nigeria Limited, SPDC, the pipeline operator, a Nigerian company and a subsidiary of Royal Dutch Shell, RDS. It was alleged that RDS had breached its duty of care under the common law of negligence. SPDC, the Nigerian company, was alleged to have committed statutory wrongs and trespass, breached its duty of care at common law, and incurred liability under the law of nuisance and the rule in Rylance and Fletcher. The claimants complained of the severe adverse effects of the respondents' activities on their land. Due to oil spills, the natural water sources in the claimants' communities could not be used for farming or other purposes. Fish and shellfish stocks had been substantially depleted. Mangrove forests had been destroyed. Plants and trees that could have prevented soil erosion had perished. Farmlands had been polluted and fish ponds contaminated. Properties had been damaged by airborne hydrocarbons and the ingress of oily water, rendering island communities uninhabitable. The claimants contended that the respondent had culpably failed to prevent, mitigate, or remedy the oil contamination, and consequently were liable to compensate the claimants in respect of the harm suffered by them. The respondent's defense was that the major source of oil pollution were crude oil theft and related oil spills, as well as artisanal refining and oil spills from assets controlled and operated by third parties, all matters for which the respondents could not be blamed. In any event, it was submitted that the claimant's allegations before the English court were not questionable under Nigerian law. SPDC, the Nigerian subsidiary, raised a jurisdictional challenge. Now, Mr. Justice Fraser, the English court, the first instance, held that there was no arguable common law duty of care owed by RDS, Royal Dutch Shell, and so there was no anchor respondent. Thus, SPDC's jurisdictional challenge succeeded. What SPDC was saying was typically, in India, you have a similar principle, I believe. When you sue someone outside of the jurisdiction, what you often do is you often say that that person outside of the jurisdiction is a proper and necessary party to litigation properly brought against a defendant within the jurisdiction. So RDS and SPDC argued, well, there is no common law duty care owed by RDS, the main defendant. If there is no common law duty owed by RDS, the case against RDS falls away, and the subsidiary case, the ancillary case against SPDC has nothing to stand on. So that also falls away. Thus, that was what SPDC argued. Mr. Justice Fraser's decision was upheld by a majority in the Court of Appeal. The claimants appealed to the Supreme Court on this jurisdictional question. The Supreme Court allowed the appeal, holding that the claimants had an arguable case that RDS owed a common law duty of care and jurisdiction was accordingly well founded against SPDC. RDS's foreign subsidiary company as a necessary or proper party to the proceedings, that is SPDC, as the foreign subsidiary company, was a necessary or proper party to the proceeding, at least provisional, at least for the purposes of having an arguable case. Now, the Supreme Court, the English Supreme Court, in its judgment, referred extensively to an earlier decision in Vedanta Resources and Lungawe to bring out its case. In the interest of time, I'm going to skip that. But the main point that the Supreme Court stressed was that in an interlocutory challenge, it was not appropriate to engage in a mini trial and decide contested factual issues based solely on affidavit and documentary evidence adduced before the court. The only matter to be evaluated at the interlocutory stage was whether the claimants had made out an arguable case that RDS, the parent, exercised de facto control over SPDC's pipeline operations in Nigeria. The Supreme Court considered the requirement of control in establishing a parent's liability for its subsidiary. And the Court of Appeal had been, the Supreme Court said that the Court of Appeal had been mistaken in thinking that the promulgation by a parent company of group-wide policies or standards could never by itself give rise to a duty of care. So the allegation was RDS, the parent in England, has control over SPDC because it issued guidelines. The Court of Appeal said no case whatsoever, because the mere issuing of guidelines, so what? The UK Supreme Court says, well, we have to look at the evidence much more deeply. We have to look at, when you look at the question of control, the starting point of analysis was looking at the functions, looking at exactly what power of control in the functional management to the parent company, RDS, had over SPDC in Nigeria. This shell group in Okabi was organized along functional lines rather than corporate status. This could imply that there was a vertical relationship between RDS and SPDC, and their respective businesses were, in management terms, carried on as if they were a single commercial undertaking with boundaries of legal personality and ownership within the group becoming irrelevant. How the shell group's organizational structure worked in practice being hotly disputed, there were plainly real issues to be tried as to the degree of RDS's actual involvement and control over SPDC's operations. Thus, a parent's management model will have significant impact on whether a claimant can sue a parent company at its domicile for the acts of a subsidiary elsewhere. The issue is fact-sensitive, and there are no specific categories into which all cases of the parent's liability can be shoehorned. So following the Supreme Court's decisions, the claims in Okabi were remitted to the High Court for determination of outstanding jurisdictional challenges in light of the guidance given by the Supreme Court. The jurisdictional challenges were finally resolved by agreement, and the parties accepted that the court had jurisdiction to determine the claims. As in the Perenco case, Victory in Okpabi before the highest appellate court was merely the first salvo in what is bound to be a long legal battle against Shell. There remains, for instance, the question of whether RDC or SPDC, or RDS or SPDC's conduct could give rise to liability under Nigerian law. In the jurisdictional challenge, it was assumed that the issue of governing law would be approached on the basis that the laws of England and Wales and the law of Nigeria were the same. But the respondent's case in the substantive proceedings is that the impugned acts did not give rise to liability under Nigerian law. As can be shown from the latest judgment in the litigation handed down in April 2022, in which consequential directions to a group litigation order were given, the proceedings are still very much at a preliminary stage. The third case, Akpan and Vereiniging Milieu Defensief against Royal Dutch Shell. This Dutch lawsuit was analogous to Akpan. It was brought by Friday Alfred Akpan, a Nigerian farmer, and Vereiniging Milieu Defensief, Friends of the Earth, Netherlands, against RDS, Royal Dutch Shell, and SPDC, once again, before the District Court of The Hague at first instance. Akpan complained that his fish ponds and farmland in Nigeria had been damaged by leakage from an oil wellhead. Milieu Defensief claimed to have locusts as its purpose was to protect the environment. The District of the Court of The Hague took the view that Milieu Defensief had standing under Article 305A of the Dutch Civil Code. Akpan's claims, if upheld, would benefit the community and the surrounding environment. There would be efficiencies to Milieu Defensief, bringing a collective action as part of its work to eliminate pollution in Nigeria, rather than multiple individuals within the community bringing action. The mere fact that the relevant environmental damage had occurred in Nigeria was not a bar to the application of Article 305A. Jurisdiction could be asserted over RDS as its head office was in the Netherlands. On the other hand, SPDC had been correctly joined as a necessary party as the facts of the cases were strongly linked to it. Nonetheless, according to the district court, the district court, the Hague court, could still exercise jurisdiction over SPDC even if the main action against RDS failed. The district court concluded that leakage from the wellhead was reasonably foreseeable, even if the wellhead had been sabotaged, and SPDC failed to take reasonable steps to prevent such leakage. SPDC was therefore liable as a matter of the applicable Nigeria. However, the district court found that as a parent company, RDS could not be held liable for SPDC's permission to staunch the leakage. The Court of Appeal of The Hague, however, reversed the district court as far as the possibility of RDS's liability under Nigerian law was concerned. The Court of Appeal held that RDS owed a duty of care, and subject to further investigation of the facts, it was conceivable that RDS had breached that duty in Akpan's case. In determining whether RDS could be liable under Nigerian law, the Court of Appeal considered the Vedanta, the English Supreme Court case, which would have persuasive value as a matter of common law in Nigeria. For some reflections, I set out 6 thoughts. First, what emerges from the 3 decisions just summarized is that environmental activism is an uphill. Transnational environmental cases are likely to go from first instance, cessation or appeal, on preliminary issues such as jurisdiction, applicable law, and where the NGOs involve locus. Even if the preliminary issues are overcome and an arguable case is made out that Yamazaki State has jurisdiction, domestic, not foreign law is applicable, claimants will still have to prove their substantive case, hopefully with the assistance of documentary evidence obtained through more generous disclosure regimes available in the courts of Yamazaki. Where a community of individuals seeks compensation for environmental damage to its livelihood, the quantum sought is likely to be substantial, making it worthwhile for respondent multinational to use its substantial resources to put up strenuous resistance. It may be years, before litigation achieves an outcome, let alone a favorable result for claimants. Deep pockets will be needed so that in many cases, claimants will simply not have the money to surmount the hurdles of showing an arguable case under domestic law and overcoming the instinctive application of foreign law by a court pursuant to orthodox conflict of law principles. Without the legal help and financial backing of NGOs, a substantial number of cases may simply not see the light of day. Second, if the three European decisions are any guide, the three paradigm cases will typically involve claimants from less developed countries seeking redress in more developed jurisdictions with strong environmental protection laws. Typically, the relevant laws in the economically developed jurisdiction, Yamazaki in our paradigm, will impose a duty of environmental due diligence on a parent company, including ensuring that subsidiaries adhere to certain norms regardless of the countries where they may be situated and regardless of the legal regimes in those countries. It will also often be the case that the developed jurisdiction will have more liberal document disclosure regimes. This means that if the initial hurdle of showing an arguable case is overcome, the claimant may be able to obtain evidence in the process of disclosure that will assist one's case. Third, a country can, through the promulgation of environmental standards in its domestic law, promote or influence environmental due diligence among the subsidiaries, wherever situated, of parent companies domiciled in that country. But such use of domestic law may have consequences. Multinationals may decide it would be better to situate their headquarters or in other jurisdictions with more relaxed environmental standards. Depending on how significant the parent's presence in Yamazaki is, a move away from Yamazaki could have serious social and economic repercussions in Yamazaki. From the perspective of the country in which the environmental damage has occurred, Xanadu, or in our paradigm, there may be resentment at the, quote, intermeddling, close quote, of a foreign court, compelling a parent in Yamazaki to ensure that its subsidiary in Xanadu adheres to environmental norms which are higher than those specified in Xanadu's existing law will increase the subsidiary's operational costs to the point where its business may become uncompetitive in Xanadu. If the subsidiary in Xanadu closes down as a result, that might lead to local employees losing their jobs and could constitute a blow to Xanadu's efforts to attract foreign direct investment, FDI, and improve the economic well-being of citizens. Four, the discussion in the three decisions of a parent's de facto control or dominant influence over a subsidiary are roughly similar. The mere fact that a parent subsidiary has caused environmental damage in Xanadu will not necessarily be enough to pin liability on the parent in Yamazaki. It will be necessary to engage in a closer analysis of the company group's corporate structure to ascertain whether, as a matter of fact, the parent exercised control or influence over relevant conduct of the subsidiary. As such an approach to the liability of a parent may lead multinationals deliberately to structure their group operations in a way that will make it difficult, if not impossible, to establish that the parent exercised control or influence over the subsidiaries. Fifth, one might inquire what scope there is for a court directly to hold that by allowing its subsidiary to conduct business in a foreign country in a way that degraded the environment, a multinational can contravene the human right to a healthy environment. And two, the victims of subsidiaries' action are entitled to claim relief against the parent company in the latter's home jurisdiction for violation of their human right to a healthy environment. In Arjun Gopal and Union of India, the petitioners who resided in India were concerned about the poor quality of air in Delhi and the national capital region of India, especially during the period of Diwali. They pointed to evidence that because of the widespread use of firecrackers, the presence of harmful particulates in the air in Delhi would normally increase to emergency levels. The petitioners therefore sought an order that the Indian government take measures to reduce pollution including by regulating seasonal crop burning, the dumping of dust and other pollutants, and banning the use of firecrackers and similar explosives during festivals. In deciding the petition, the Indian Supreme Court held that it was entitled to direct the Indian government to deal with pollution during Diwali and to grant interim relief pending such action. The Supreme Court took the view that it was the duty of the state to ensure a healthy environment in terms of Article 48 of the Constitution of India, as well as the duty of citizens to ensure the same under Article 51, capital A, little g of the Constitution. Since the existence of a duty owed by A to B implies the existence of a corresponding right maintainable by B against A, it followed that the petitioners had a human right to a healthy environment. The Supreme Court made this clear when it considered the argument that banning fireworks would lead to extreme economic hardship, namely, on the one hand, loss of substantial revenue, and on the other hand, unemployment to lax persons. Justice Sikri, Arjun Sikri, stated, in the first blush, it may appear that the aforesaid arguments of economic hardship has substantial force. However, that would be only one side of the picture, as there are contra-arguments which are sufficient to take the sheen out of the aforesaid plea. First aspect is that the argument of economic hardship is pitched against the right to health and life. When the court is called upon to protect the right to life, the economic effect of a particular measure for the protection of such right to health will have to give way to this fundamental right. The decision is heartening in its boldness. I understand that as a result, in due course, legislation regulating the use of fireworks during festival time, among others, was passed. But notice that in the case, the petitioners were Indian residents of Delhi. Plainly, the human right, which the Supreme Court discerned from the Indian Constitution, was one which they were entitled to maintain against the state, which owed them corresponding duty. But it is far from apparent that the foreign victim of environmental degradation abroad, brought about by a multinational's activities, would be able to assert an analogous right before, say, the Indian court. The Indian Constitution, for instance, provides in Article 14 that, quote, the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. In the circumstances, a wrong inflicted outside the territory, even if it might be characterized as a breach of a human rights norm, would not without more be actionable as a breach of constitutional right. Indeed, the alleged wrong perpetrated abroad by, say, the subsidiary of a multinational company will likely be perfectly in accord with the laws of the relevant foreign state. The consequence is that in private international terms, we run up against the same impediment that we encountered at the start of my lecture. While the court of state X may conceivably accept jurisdiction due to an alleged wrongdoer multinational being resident in state X, the applicable law will involve the law of the foreign state. Under that law, no wrong has been committed. 6, I have not lost sight of the question with which I began this lecture, namely the role of a fair-minded judge who is faced with litigation like paradigm cases 1 and 2. The question boils down to how proactive should that judge be? A judge must be impartial in the way that he or she decides a case. But as we have seen, along every step of the way in transnational environmental litigation, there will be issues that do not admit of a clear-cut answer. Different judges may reasonably disagree over whether an arguable case has been made out. The appellate court in Perenco or Pabi, for instance, decided that on the material and facts before them, the claimants had no reasonable prospect of success. And so they held that the relevant actions should be nipped in the bud. The apex courts in both cases held, to the contrary, that the lower courts had been too hasty in coming to their conclusions. Much as a fair-minded judge should approach any case with a bias to doing justice, should a fair-minded judge approach a case with a bias in favor of protecting the environment and ensuring that those who have caused environmental degradation should bear the true economic cost of their activities? In more neutral words, where the facts and law may reasonably be construed in a way which favors the victim of an environmental wrong, and in another way which favors the alleged wrongdoer, how does the judge, the impartial judge, choose between the two options? There may be no easy answer to this dilemma, and perhaps the best that can be said is that it all depends on the facts and everything is a case. Let me go finally to say a few words about climate change. I use the expression climate change and global warming interchangeably as shorthand for the phenomenon whereby an ever increasing emission of greenhouse gas has led and continues to lead to a rise in the temperature of the Earth's atmosphere, thereby affecting existing weather patterns. I will take it as axiomatic that climate change is one of the greatest threats facing humanity today. I realize that there are still many who take the view that climate change has been overly hyped as an occurrence or a pressing global problem. This is not the appropriate forum to debate whether climate change is or is not happening. Those who do not believe that it's happening can simply switch off at this point in the lecture. In the premises that I've identified, the effects of global warming are not benign and will adversely affect our lives in the not too distant future if we fail to act now to mitigate its effects. The question is, how should we deal with it? There is the problem of the evidentiary gap that I identified. Even if a court accepts jurisdiction, a real difficulty faced by a claimant in establishing a cross-border action seeking compensation or other form of redress for the adverse effects of climate change is to establish a link between a natural or legal person's activities on the one hand and the injury to one's health or livelihood on the other. This evidentiary gap can be illustrated by many cases, but one that I refer to in the version that in the typed out version of my lecture is native village of Tibalina in ExxonMobil. Because of the time constraints, I'm not going to go into that case, but the court there was unable to bridge the evidentiary gap. So how can we do it? Given the present state of our scientific knowledge, one might wonder whether the evidentiary gap in Tibalina can ever be bridged in practical terms. The question, though, is can we wait until our knowledge develops to such a point that the adverse effects of climate change can be established to the requisite civil standard, balance of probabilities? There is a risk that such point in time may be too late to deal effectively with climate change. We do not have the luxury of time. So I suggest that one way of dealing with this is to apply the precautionary principle. Now, the precautionary principle was, amongst others, places enshrined in Principle 15 of the 1992 Rio Declaration on Environment and Development. The principle is, in order to protect the environment, the precautionary approach should be widely applied by states according to their capabilities. Where there are threats of serious or irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. That's the precautionary principle. Note that the precautionary principle does not apply to every sort of damage. Damage is qualified by adjectives such as significant, serious, irreversible. There is a threshold to be met before the principle is engaged. Moreover, proportionality is built into the principle. States are not required to do everything, come what may, prevent or minimize all causes of climate change. A country is only required to take measures which are cost-effective and take account of relevant socio-economic contexts. As far as the evidentiary gap is concerned, the precautionary principle might help to bridge the same, where a court is asked to injunct an activity which could lead to large greenhouse gas emissions and potentially significant climate change effects. It may be difficult in such a case to establish on the balance of probability that the activity challenged would have the dire effects alleged. But if there is at least some evidence that severe effects could result from the activity, and the court is not satisfied that sufficient measures have been taken to mitigate those potentially harmful consequences, the court might issue an injunction based on the precautionary principle. Despite the absence of compelling proof, which is currently not possible, the court should err on the side of caution. As a possible corollary to the foregoing, the more serious the possible effects of activity, the lower the standard of proof the court might apply. Would any of this, have helped the inhabitants of the case Kivalina, which I referred to just a moment ago? I'm afraid not. The damage the village was suffering was significant. It suffered the damage. The villagers were looking for economic compensation. The precautionary principle looks forwards, not backwards. Where a court is faced with a claim that substantial damage has been inflicted by some activity, and what is being sought is financial compensation, as opposed to an injunction or an order that a respondent take steps to mitigate potentially harmful effects, the horse will already have bolted from the stable. The damage will already have been done. An injunction, similar order, will be of little use, and the precautionary principle will not be able to bridge the evidentiary gap in establishing causation for the purposes of damage. I thank the ISIL for inviting me to address you all. It's a great privilege to do so. I've come to the end of my lecture. Thank you very much for listening.
Ladies and gentlemen, Justice Anselmo knows more about Indian Constitution and the Indian court than I know, and I therefore declare him as an Indian citizen. In addition to his own citizenship, he will continue both. Thank you very much. Yes.
Well, I thank Justice Anselmo for a very enlightening lecture. He has raised some very important issues. We are all familiar in India with this difficult question of balancing environment and development. We have a large number of poor people in India who need jobs, who need shelter, and who need other basic necessities of life. And the industries which we need to provide these, as we know, they all contribute to pollution. So how much pollution can be accepted? As Justice Anselmo Reyes mentioned, it's very difficult as to where you draw the line. How much pollution is too much? And where do you take immediate action? In fact, the major cause of pollution has been the rapid rise in the world population in the last century. In the last 100 years, the world's population has gone from 2 billion to 8 billion and is still growing. And to put that in perspective, we have increased 6 billion in 1 century. But before that, it took about 125 years for the Earth's population to go from 1 billion to 2 billion. And right now we are adding 1 billion people in every 12 to 13 years. And all these people, they need food, they need shelter, they need work. And all of that contributes to climate change, to the worsening environment. So with these thoughts, I would now open the floor to any questions that you may like to ask. Yes.
Looks like I wanted to ask one question. What the for cause of the pollution or there is a local government they are implementing. So what is the scope when the courts have generally refused to enforce the local law? against a foreign person or entity whose doubtful or impugned conduct occurred outside jurisdiction. Oh, that is that is a good definition.
I wonder if you might repeat the question because I didn't catch all of the question. In particular, the preamble to the question. I wonder if you could just repeat the question.
What outside cross-border portion? Just I'm wanting to know that generally local laws cross-border legal portion they are using as the local laws. So just I wanted to know what is the scope when the courts have generally refused to implement or to enforce the local law against a person, against a foreign person or entity when whose doubtful or impugned conduct occurs uh, outside that jurisdiction or outside the state or country, and how that liability will be paid from established.
I can't give you figures for that at the moment. I can't give worldwide figures. What I've tried to do in the lecture is to give some examples of courts that have accepted that it may be possible to apply domestic law to govern or regulate the conduct of typically a subsidiary or an associated company or law. Now, the mechanism is a little bit complicated because there must be someone within the local jurisdiction, within the domestic jurisdiction, to be sued. And usually that will be a parent. It will usually be the subsidiary or associated company abroad that has taken advantage of the more relaxed laws abroad to engage in economic activity that causes pollution or causes environmental damage. The way that a number of countries have tried to regulate it or trying to regulate it is to pass laws that impose duties of due diligence on the parent companies situated within typically a developed country. So that even if you have a subsidiary or associated company abroad in a less developed country, you must still comply with the environmental standards or the environmental due diligence requirements of the parent's home jurisdiction. Now, the question I've been trying to explore, and I'm afraid I'm not able to give you more statistics to answer your question directly, is to what extent have judges been applying these domestic laws? It seems it's an open-ended question as far as I can see. Judges have, or courts, typically the highest courts, have allowed litigation to go on, have not struck it out, not terminated it prematurely. But that's only the beginning. The end question, the proof of the pudding, what happens when you deal with substantive matter? I'm not sure we have enough data on that. Now, there's some promising cases in the Netherlands where this has been happening. I didn't cite those recent cases in the Netherlands, but those are still few and far between. And the real problem for someone like me as a judge is even let us say I am very passionate about human rights, I still have to be impartial. I still have to listen to both sides. I still have to come to a fair decision. So how do I do it? My conclusion is I can't do it alone. That is to say, I need you as professors to teach students or to equip students to raise the arguments for and against. Once you raise the arguments before me, I have to decide. But I can't do it of my own motion. You need to have the lawyers of the future who are sensitive enough to the issues to raise the issues both sides. You need a community that is alert, aware to these environmental debate, very much like the president and the secretary general identify how is the balance to be drawn. You need legislation that attempts to draw the balance in one particular way. So at the end of the day, the question we're trying to get, the judge, how does the judge do it? I'm not sure the judge can do it alone. And so I'm not sure that the courts alone can answer your question. You need to have the whole community engaged to deal with the matter of using domestic standards to enforce environmental due diligence subsidiaries for.
Just one.
Thank you.
Uh, in the context of climate change, context of climate mitigation,
There are two questions. Just a moment. I'll take the one first here, and then I'll take the one.
yes, in the context of climate change mitigation, there is one clear strand that is emerging. General ambitious emission cut in the context of 2 degrees Celsius.
You have to speak to the microphone so I can hear.
I'm saying that the general ambitious emission cut in the context of 2 degrees Celsius that is translating into duty of care, duty of due diligence, intergenerational equity, precautionary principle. There are a number of judgments. I think you are well aware, like Urgenda judgment. There are several judgments in jurisdiction from Germany. There are several jurisdictions. If you read the judgments, basis is general ambitious emission cut duty of care, due diligence, rather than those claims based on pecuniary interest. So this is a clear cut strand in the context of climate change. So first question. Second is that in order to remove jurisdictional challenge, the UNEP draft principle 1978, perhaps you must be aware that the principle 14 of UNEP 78 that the states should endeavor in accordance with their legal systems and where appropriate on a basis agreed by them to provide persons in other states who have been or may be adversely affected by environmental damage resulting from the utilization of shared natural resources with equivalent access to and treatment in the same administrative and judicial procedures and make available to them the same remedies as are available to persons within their own jurisdiction who have been or may be similarly affected. This principle 14 of 78 draft code of India. This has been not followed up. This has not been taken care of by international community who are really concerned about environment.
I think please ask him to reply to it.
So these are the
Yeah,
two
yeah,
questions
no
that,
reply
that,
in your opinion.
that I would like you to address it.
On the first, I agree. I agree that the strand of litigation that we're seeing, probably the most successful strand, as seen in the Dutch court, in the Dutch case of Uganda, is suing a government for failure to take steps, proactive steps to lower emissions by, let's you said, 2 degrees.
Yeah.
So that is a strand that's emerging, but that's not enough. It doesn't compensate the victims of actual environmental damage. On the second matter, equal treatment.
Yes.
Now, again, it's difficult to know how far that can go because even what you read out, the states within their economic means, within their circumstances. So there's always a little catch. There's the question that the Secretary General just raised a moment ago. It's a balance. The court cannot draw that balance. The court can order a government somehow draw the balance, but no one has brought a case saying requiring the court to order the government somehow to strike a balance as to what legislation is actually put out. Yes, in the case of lowering emissions, but beyond that, the rest is very, very vague at the moment. Your question.
Thank you for the enlightening lecture, Your Lordship. You cited the Indian judgment by Hon'ble that
Yeah.
Sir, and you gave your observation that if the first time it should be adopted in the environment cases. So if the environment impact assessment, EIA report is submitted like in it's of farm financial. Would you suggest that we should adopt replication models and the Russian side also, like the combination of precaution with the people?
Thank you. One of the last cases that I was involved in Hong Kong before I became a judge there was relating to precisely this question. I acted for the environmental protection at the time. I think it was simply the department, EPD, in Hong Kong, and there was an EIA, and we were arguing that the precautionary principle should carry the day because we weren't. What was being proposed was that a railway be run through some marshland, which was the only remaining, well, this marshland site in a part of Hong Kong called the New Territories. That also happened to be a particular environment for special species of birds. And so we were arguing that you shouldn't run the railway through. You should instead take some precautionary measures in order not to risk harming the rare bird species that were there. The railroad said, well, no. We can create an environment so that for all the construction, the birds will come back and it'll be even, but we're not sure of that. Couldn't be sure about that. And I think we prevailed so that the tribunal applied the precautionary principles. So I think the mere fact that there is an EIA is not enough. The EIA will simply give you what are the likely things. But at the end of the day, someone has to decide how certain are you about this? If you're going to lose some very rare species of birds in Hong Kong, then preventive principle. If it's only the sparrows that you see every day, maybe that's fine. It's not going to be severe. If it's going to be severe, then an EIA by itself will not be sufficient. I think we need to say precautionary principles. Yes. Yes.
So my question is that regarding the jurisdiction by the polluter forms, the jurisdiction of the state where the victims are situated or where the pollution occurred, there is a growing literature that there should be an international environmental code. So that can, in my opinion, that is not enough because that will create only a super class of the elite lawyers at the international level. Not that the victims access to the just a judicial forum. But what is your opinion and observation?
Um, it doesn't seem to me, you say that there's a lot of literature now on the need for it in international environmental court, but I don't think that's going to happen anywhere in the near future. So there is a problem. There is a lot of literature. Academics, by all means, write and press for such a court. But politically, I think that's going to be a difficult matter. Because again, we go back to the Secretary General. You're balancing economic development against the environmental future and how exactly different states will draw the line, the balance in different ways. I'm not sure you can force all states to be part of the environmental court. The states will say why.
Well, I thank you all for your participation, active participation in the program. I thank Justice Reyes for accepting our invitation to come to the Indian Society of International Law and address the conference on this very important topic of contemporary relevance and especially of special relevance to India as well. As we saw during the questions, there has been a lot of litigation, number of cases that courts in India have had to try and balance these concerns. They have not always succeeded, as we have seen recently in the Char Dham highway, where the court was taking a strong line, but then the government says, no, we need this for strategic reasons. Yes. And then the court withdrew from that stand. So there are conflicting views, conflicting issues to be taken into consideration. And So we thank Justice Reyes for highlighting the issues and how the Supreme courts have addressed this problem. And I'm sure that this will be of great interest to all of us. And I also thank the President, the members of the EC, and all the members of the society who have come to attend this lecture and to benefit from the views of Justice Reyes. We thank you all.
Please join us for a cup of tea upstairs.
Yes. They were taking you. Honey, you don't love it like that when we get it. So you came with it. It's what man for it. Thank you. We don't need rains for the camp to take us from now. I don't need much better. What's the hit? You can get see. I need to be sure it's not to leave. You have to contact the town. My cameras. So, I need to skin. It's going to looking for a good just yes, yes, my dad is here. Just got a lot of time of the